area or in a particular industry or in a particular sector of the Nigerian economy is moving very fast. The development and everything is moving at a very fast pace. The reality is that disputes will naturally just pop up, because it's a gray area. People are just testing the waters. People are just trying different things, get themselves to acclimatize with this process. So the whole tech space and also the whole telecom space, especially with the advancement of now 5G, for instance, now who is going to give license to who? Will everybody have to go and build their infrastructure in those rural areas? All these various issues are coming to us lawyers as new issues, and also the clients are coming to us to ask for urgent solutions. So typically, sometimes they will come to you and then they come in very familiar tone. For instance, they come in the tone of, this one is breach of contract, is negligent, or basic IP infringement, But beyond that, actually, what you will then see is that this set of disputes, this set of issues come with the need, or with the dying need for technical understanding. So if you're a lawyer and you need to provide an advice on a potential dispute or whatever it is to a client in the telecom space dealing with 5G, for instance, say for instance, MTN reaches out to you. Oh, we are dealing with this. These are issue. We've gotten the license. These are problem. And if you try to understand it from a perspective of basic breach of contract, bring the contract, let's review, or negligence and all whatnot, you might get caught up, and then you might just give your client not so great advice. So it requires a basic level of technical understanding. You need to know the terminologies, what is obtainable, what is actually happening. So when they say this, what are they talking about? When they say that, what are they talking about? And beyond just us lawyers, it's also necessary for us to, as lawyers, push for a level of, in summary, there are very few judges that have very technical knowledge on some of these bits. I'll give you guys an example. I have a matter that I'm doing for a company, and then we are before a judge. We have gotten to the point of adoption, and then it's an IP related matter, right? Copyright of a source code and everything. And then at the federal court, we are done with that. We are done with adoption, and then the judge looks at everything, and then the judge says, "You know what? I'm going to make an order portion to the federal court rules, writing to NCC for NCC to advise me on what exactly." Because I don't understand everything that you guys have been saying for the last 3 years. So you can imagine taking that kind of news to the client. First of all, yes, it's good. Comment on the part of the judge is quite commendable, where you can tell you can say, okay, the judge does not understand. The judge is making an effort to understand, but also it's also a setback for your client, who most likely might not. Who wants results in the next 2-3 years, and then they're saying they want to write to NCC and to provide an expert opinion and advisory on the whole subject and all whatnot. So you need to also, we as lawyers also need to push for this level of expertise, so that for some of us that are going to go to the bench, even as this whole tech and telecoms industry are pushing, the trajectory is pushing on a very high pace, and then we have people there on the bench. We get people who are actually experts, or who have at least a basic understanding of how some of these things work. Before we dig deeper, I just want to set the coordinates. What exactly is technology? So when we say technology, I'm sure we all remember JSS2 or JSS1, where they will say, technology, and that's why I brought that definition here. There's no widely acceptable definition of technology. Technology is just anyone's attempt to apply a practical solution, or apply. Okay, let me just read it out. It's a practical application of scientific knowledge to tools, software systems. At the end of the day, the main aim is to solve real world problems. So any attempt by anybody to actually use scientific methods or tools to solve real world problem, that's sort of trying to develop a technology. So in the legal world, we refer this to innovations like software, AI, which is now the talk of the day: cloud computing, cloud engineering, digital platforms, database, algorithm, and all these things. These are people's attempts to employ practical scientific tools in solving real world solutions. So that's essentially technology. So when we hear technology, that is what we're talking about. Somebody attempting to use, or somebody successfully using scientific tools to solve real world problems. So that process is what we call technology. Telecoms essentially is very straightforward. It's just about the transmission, reception, and exchange of information using electronic means, including voice, data, video, internet, and it relies on a lot of things, infrastructure, like the infrastructure, hardware, softwares, the softwares we have on our phone, and then ranging from the softwares we have on our phone down to the mass that we see, and a lot of things that happen behind the scenes. So that's essentially what telecoms is all about. Just to confirm, are we together?
Yes, we are.
All right, great. And if I'm moving too fast, you guys can just always bring me back. So we'll move to the next slide, which is IP rights in technology and communication. I think this is the critical part of this conversation. When we talk about IP rights, we already have an idea of, I think a good percentage of the audience are all lawyers, but just for context, intellectual property rights are the rights that accrue or that come to you when I mean, this is a basic fundamental definition. When you develop something, when you create something, the rights that accrue to a creative, that's essentially what intellectual property rights is about. So so there are various intellectual property rights. So did my slide stop sharing?
Yes, it did.
Wow. My sincere apologies. I'm trying to get it back up.
Oh, no problem, sir. We understand technology.
And we're talking about technology, interestingly.
Very ironic. That's interesting. Okay.
It's back, right?
Yeah. Yeah, it's back. Your screen is back, so you can see the slide now.
All right. So I was talking about the various types of IP rights that are involved whenever we have to deal with technology, and then within the space of telecoms as well. And there are various rights. The first one I identified here is what we call copyright. Recall that I had said that IP rights are essentially the rights that accrue to someone who invents something, who creates something, who develops something. This is just a bare contextual definition for the purpose of this conversation, right? And I said the first one here is copyright. In the telecoms and technology industry, this is one of the most important rights that accrue to creators, creatives rather. When you talk about copyright, you are talking about the protection the protection that someone who had expressed his idea is supposed to get. So it's very critical that you know that as far as copyright is concerned, it is not just about having your ideas. These are and typically sometimes lawyers just try to limit copyrights to just movies, literary works, and all whatnot. So it goes beyond that. It actually extends to technological efforts that are being made by people within various industries. So if someone sits down to put up, for instance, develop a code or a software, like again, just to bring it down a bit more, a source code or a code, as it were, is just a set of instructions that are usually being written by our engineers, in their own languages, whether it's Python or whatever language they use, C++, C#, whatever language they use. These are various languages the engineers use. Those technical bits, the engineers sit down there and then they use those language to write down instructions, and then they send it to our computers to then execute. So those code, those are what essentially are called source code. And then those source codes, the law, the Copyright Act 2022, makes provision for the protection of this source code, depending on the circumstance that you have to deal with. And then we'll get to some of those circumstances subsequently within the, later in this slides. Mobile applications are basically mobile applications have been developed for you to use on your tablets and your phone and all whatnot. Databases, APIs, web content, technical documentation. Technical documentations are the conversations, or those technical details are then put in the documents. Usually when you want to build a website and then you tell your engineer or whatever it is, oh, this I want it to work, this I want it to work, this I want it to work. And then all those things are lumped together. Those technical details, the engineer then processes those technical details, and then for some reason you wake up next day and then you see the website. It also applies to telecom. When you want to build your 5G network, or when you want to operate your 5G network, what are the kind of things you are putting in place? Those technical instructions that are usually not out there in public, they are just they are just within your organization, or within your company, or within just your engineering team. Those technical instructions are sort of can be categorized under copyright. I remember I said, and this is not to belabor the point, but remember I mentioned that as beautiful as the law on copyright is, it only protects ideas that have been expressed. So if you have a wonderful idea in your mind that has not been expressed, it will be difficult. It will be difficult for you to protect same, or for the law to support you, assist you in protecting same. So as lawyers, we need to always have that in mind. So no matter how beautiful your thoughts are, if it has not been expressed, it will be difficult for you to be for it to be protected. There is also the second set of IP rights that are usually applicable within the technology and the telecom space, which is also called trademarks. The trademark is regulated by the Trademark Act 2004 LFN. T13, T13. There is currently an ongoing attempt by the National Assembly to repeal that law. There is a bill that I think just passed the first reading late last year, I think December or so, late last year, which I think it is very commendable in view of the kind of amendments they are trying to bring in, or the kind of provisions that are coming in under this new law. But essentially, what you need to know about trademark as far as technology and telecoms are concerned is that trademark is what people see outside about your business. So what is the name of your brand? MTN. What is the name of your brand? Telecom. In maybe a fintech company, oh, Zap. You hear Paystack saying, oh, Zap is our brand. You hear another company coming to say, no, we used to have Zap before. I'm sure we all saw all those tweets and everything during I think mid last year or so. So the trademark protects your logos, your trade name, your business name, and then your company name from being exploited by other people. So if a company in the telecoms industry, or anyone building technology, in as much as those technical bits that are covered by copyright are important, it is very, very important that your trade name, whatever you want to use to market your product. At the end of the day, when we develop anything, it's for us to market it. So we don't just develop to keep at home. We want to put it in the market for us to generate revenues. In very rare occasions, we see people just develop that, are just developing for the fun of it. So for you to go to the market, you need a name, and that name has to be unique. That name has to be distinctive, and that is what is covered by trademark essentially. The third one here is patent and design. I try to just lump patent and design, even though they are governed by the same law in Nigeria, the Patent and Designs Act. there are two different forms of IP rights, but again, we'll just take them together. Designs, as it were, I would just try to give a bare definition so we can all work with it. We can have a basic understanding of what we're talking about. A design is the external form or structure of an idea. So let's say you want to develop, you want to build a bottle. The shape of the bottle, there are times when you see the shape of Coca-Cola, right? When you see the shape of Coca-Cola, that is the design of Coca-Cola as registered in the designs registry. Now, the other technical details. Now, that's just what people see outside in terms of shape, and the physical features that you can clearly see. So for every product, it's always important that you develop. You find that when you go abroad, there are some in some countries, there are some of the network providers that have a specific way of building their own, I think their own masks, and then a couple of other things. So when you see it, you're able to say, oh, this one is these people, this one is these people, this one is these people. And that goes for every technology you are trying to develop, especially for those ones that are not soft technologies. And now soft technologies are the ones that, you have access to, or you enjoy the benefit of the service, or you can interact with that technology using your laptops and everything. Now the ones that now need physical infrastructure, that will mass insistors, transistors, and all those things that will then be put physically down. Those ones, your design, your shape, if you have to protect it, right? The proper way to go about is to look towards the angle of design. So design rights is a branch of IP or IP right that makes protection for the shape, form, and then the outer look of your idea, as it were. And then the patent has to do with the technical bit, the technology, the ownership of the invention, the authorship of the invention, who is supposed to own the invention, that when you invent, that the process that you use to develop your invention, that is what patents sort of protects. That process that you use, so that someone else does not go and copy your process and then duplicate it and then start using it and then sort of exploiting your process and then selling it to the market at a lesser value. So when we talk about IP rights, the concept of patent is that branch of the IP right that protects the process of your invention, whether it's a technological concept that they're developing, whether it's within the telecoms, and we all see the 5G, the whole 5G dramas, and then that has clearly taken over the telecom space in the last about 1 year plus now. That's so you already know, for patent and design, for a design to be new, for a design to be registered, it needs to be new, it needs to be novel. The law is very clear. If it's not novel, if it's contrary to public policy, the courts will typically not admit, the registry will typically not register that design. And even if the registry makes the mistake of registering it, a party or someone can approach the Federal High Court to set aside that registration. Or sometimes, in some instances, people go directly to the registry to set aside the registration. I do a matter where we are trying to set aside, for instance, now, and I can't provide names of the parties, but I'll just give you guys the story. We're trying to set aside the design, the shape of a bottle, and that's within the FCMG space, right? The shape of a bottle that someone had registered some time ago, and then the ground was that, oh, you know what, this was not novel at the time. What does it mean for it to be novel? When a design is novel, what it means is that it's 6 months before the time the design was before you apply to register it, or earlier, you had not put it in the public space. So that's essentially a basic level definition of the novelty. And then the last concept here is trade secrets. We already know. I think this speaks for itself. Trade secrets are those personal, private informations that all the telecoms companies, the technology companies, will typically not want to put out there. They are very sensitive to their business, in the sense that if it goes out, to a third party, and then the third party decides to use it, most of the times it sort of affects. I mean, they can exploit those information in a way that can hinder or limit the business of the owners of those trade secrets. So trade secret can simply mean your customer list, algorithms, um, things information you get from people accessing using your network. You are sure that, the people in, for instance, the people in Osun State typically use, they register MTN SIM, for instance, and this is just a big example. Register MTN SIM more, and then the projection in the last 3 quarters shows that the registration increases by so and so number of percent. You have those details, those datas, and then you know that, these are the people that we engage to drive the sales, and then suddenly somebody go and picks the names of those people and then says, you know what, I am Emmanuel Agidi Network. Can you guys sell for me? And then because they have access to the list of people that drive your sale, they engage those people, and those people also start selling the Emmanuel Agidi Network, and then it becomes, obviously it's going to impact on the sale of the other company. So that's why for trade secret is very essential. The only issue with trade secret is that currently in Nigeria there's no law that sort of governs, or that sort of governs, or the protection of trade secrets. And also the practicality is that, as far as trade secret is concerned, it's trade secret. So will it still be a secret if you have to go and register it somewhere? So there are a couple of difficulties here and there, even on the part of the lawmakers. Even though they want to set up this law, how then do you protect it? So currently what they do is breach of trust. If a third party, if it's given to a third party that maybe they have a relationship with, or maybe a former employer, then you go ahead and they put out their trade secret, they would the company can sue you for breach of trust. There's this popular Coco case that talks about it. A former employer this, using some of the trade secret of his employer to carry on business, that, and then the employer deciding to go after him. I had done a case where we had to sue about 12 employers from a company within the automobile industry. They had 12 of their employers who typically help them do sales, drive their sales. They left. They left with a list of customers and a couple of other things. And then clearly we had to go after them to ensure that we get, at the very least, an understanding and an undertaking that they are not going to exploit the list of those customers that drive our sales and everything. So that's sort of how the customer base, those models, internal software, the product roadmap, from on how you move to the market and who you access within the market and all whatnot. That's what trade secret is about. We'll move to now the meat of it. So why IP dispute?
Sorry to interject, Mr. Emmanuel. Your slides have disappeared again.
Sorry?
I said your slides have disappeared again, so I think we need to restart it. We can't see your slides again.
Wow. Was it just now, or?
A few minutes ago, but I figured because we were just explaining, you were not speaking directly to the slides, so I just allowed you to continue with the
Wow.
registration. So sorry, continue with the
Okay, all right. Just a minute. Let me.
It's gone again. It was back for a bit, but then it's gone again. Okay, so it's coming back up gradually. Yeah, I can see your screen now. You can see your screen now, so we're waiting for the slides to load.
Please let me know.
We're seeing your entire screen. You're showing your entire screen, not just the slide you're trying to display.
Sorry.
So you should just stop and cancel sharing and then try to share all over again. Just sharing the
All right.
slides.
So while we wait for Mr. Emmanuel to share his slides, if you have questions, please put them in the comment box, because I can't see any questions. If you guys don't have questions, I have questions, and I hope guys.
Is it back on now? Please.
Your entire screen is what is back on. The particular slide is not on yet. I think you're trying to click it to get it to load. So, or would you have me share on your behalf? I mean,
Yes, please. Yes, please.
So,
I already shared it with you.
Okay, so let me try. Let's try that. You might just have to continue the presentation while I try to load the slides for my.
So we can still see your slides, though, Mr. Emmanuel. Maybe you just continue, and then when it eventually comes up, go forward.
Yes, I'm trying to share.
I thought someone.
Yes, I'm trying to share for him.
Okay, so
I'm trying to share slides for him. So
okay.
I'm trying. I need to load it from my hand first. So you can just continue with the presentation while we fix that.
Yeah, sorry, apologies for that, guys. Just with us, but Emmanuel, you can continue your presentation when Sammy gets it up. We'll just pick it up from there, but you can please continue. Muted.
Okay. Mr. Manuel, can you hear me?
Dammy, he's muted though. We can't hear anything.
Yes. Okay, Mr. Manuel,
I can hear you. Can you hear me?
Yes, I can hear you now.
I can hear you now. So here's what I was saying, that you should probably just continue with your presentation. I'll try to share, then I'll try catching up with you on the slide. I'm trying to load
All right,
no
problem. That's totally fine. All right, so I was saying that we had stopped at looking at. I mean, we had stopped where I was trying to explain the various IP rights agreeable to creatives within the technology and telecommunications sector. Where I talked about the copyrights. I also spoke about trademarks and then patent and design, as well as trade secrets. And then the various. So I wanted to move to the next step, which is why IP dispute arise in technology and telecoms. Even now that we know the various forms of IP dispute are accruable, that you can accruable to people within this industry, then why do these disputes? Why do disputes IP dispute arise within this area? So I'd made a quote here on the face of the slide to say disputes rarely arise because parties ignore IP entirely. They arise because IP clauses are poorly drafted, misaligned, and commercial expectations, or misaligned with commercial expectation, or silent on critical risk allocation issues. It's a quote from an article that I had written earlier this year in March 2026. And I said, as far as IP disputes between the telecoms and technologies sectors are concerned, there are the two main causes of the disputes are usually categorized into two main angles. Firstly, ownership and assignments disputes. Now, the question usually you will hear is, who owns this dispute? Have they assigned it to you? It's like buying a land, who owns the land? Have they even assigned it to you, as it were? And then the second part is the licensing and contractual failures. That has to do with poor drafting and all whatnot. And I said this is very critical because for IP transactions, particularly in trademarks, patent and patents, right? Assignment is very, very key, right? If you don't own the IP, or the moment you are starting relationship with the employer, with the employer, and then there's nothing in your contract of employment that sort of says you are going to own the IP for anything you are developing, as it were. It will be difficult for you to then come back later to then claim ownership of that IP. And that is where the ownership, this is under the ownership and assignment dispute. This is the under ownership and assignment dispute. The question usually is who owns it, where it's the intellectual property. So who owns the software? Another instance where it's developed by a consultant. So you hire a consultant to help you build something, and then the consultant builds. Who owns it? Can you say it's yours? Can you say it's that of the property still belongs to that of the consultant? And then how about instances where there are joint development, where there is a joint development? So we are both engineers, and then we sit down to develop a technology. And then maybe we don't even have a JV, we don't have anything. We just wanted to put our resources together and develop something. For younger lawyers, when you have to review these kinds of agreements, you know what you should be asking is, first of all, who is going to own the IP that is going to be created during during the process of this marriage or this relationship that people are planning to go into? Is it supposed to be very clear? How about improvements or modifications? So, for instance, if there are improvements or modifications, simply means you develop something and then there are now one or two additions that sort of does not make that thing look like exactly what you had developed. So, can the person come back and then claim ownership?
Sorry, Manuel,
Sorry?
your slide is of what page to the damage picture? I think.
All right. Yeah, this is it. So thank you so much, Dami. I really appreciate it. So yeah, as I was saying, ownership and assignment is another. This is another key cause of why IP disputes. IP disputes happen within the tech sector and then the telecom and within telecoms as well. I mentioned various scenarios. I said scenario one, employer-employee relationship. The question usually that comes up is, if I hire an engineer today and I'm paying him salary, and then the engineer develops something for MTN today, or a Glow, or whatever it is, supposed to own that invention? Is it clearly set out in their employment contract? So IP starts and all whatnot, and then
your network was buffering for a bit.
Yes.
Could you just go back to when you were talking about the employment contract scenario?
Can you hear me?
It's still buffering, but yes, you can. Oh, I can. I don't
Wow.
know.
I don't know my mic, and I don't know why you still can't hear.
So I've started the video. I can hear you, but can you repeat maybe your last one or two sentences?
All right. Do you want to go? Can you go back to the other slide? The slide before this. Sorry.
Okay. Let's see. I don't know. Okay. Are we good?
Yes. Thank you so much. So I was talking about the two main sources of disputes within the tech and then the tech and telecoms industry, and I'd mentioned that the source number one is ownership and assignment troubles, and then the second one is licensing and contractual issue. In summary, I'd said there are certain relationships that requires governance, and then if as a lawyer you don't set up governance from the beginning, clearly it will be difficult for those relationships. When there is a dispute, it will be difficult for you to then resolve clearly who owns certain right within those space, within the context of those the relationship. And I then I give example of an engineer employed within a network engineer employed within MTN developing something that is very useful to MTN's business. And the question is, at what point was that right supposed to be even be assigned to MTN? Is it at the point of employment or when they want to go into that particular project and all whatnot? It is very, very critical that you make your IP clauses very clear from the beginning. And then I also made an example of consultants where you don't hire the person, you just brought the person in as a consultant who is going to own the IP where something is developed by that consultant. And then joint development where I talked about JVs, two engineers coming together to develop something, and then we as lawyers having to advise them what will be what will you be looking out for. You need to make it clear to them that these are the instances where XYZ person can own this. These are the instances where both of you can own this and all whatnot. And then cross-border ownership complexity. This is now another level to the assignment ownership. You hear foreign companies like the foreign tech companies trying to bring some of their technologies within in Nigeria, and then they don't want to do they don't want to come and establish a business here, but then they want their technology to expand to within to the shores of Africa or the shores of Nigeria specifically now. How then do they manage those? How then do they manage those technology? It's important that you remember again. First of all, basically, as you are setting up your technology, you need to register it with NOTAP. As you are transferring that technology to Nigeria, you need to register it with NOTAP, and then second, I mean, this is just a transactional, me thinking like a transactional lawyer. You need to register with NOTAP, and then the person you want to drive your market in Nigeria, you need to be very, very careful with the kind of agreements you have. We've seen situations where people have gone on to register trademarks and other IP rights in Nigeria that were ordinarily assigned to them, and then at first they'll be working for you, and then they'll keep working for you, and then after some time they'll just go and register the business and and say they are the face of the business. Again, you've not even registered that your IP right within the Nigerian registration framework, whether the trademark registry, patent and design, patent and the design registry, the patents registry, or whatever it is. You're not going to make your registration. The person you are using to do business in Nigeria has gone to do those registrations. So we need to always have at the back of our mind when we are interacting with cross-border clients that, from the get-go, do your registration first. You don't even have to a company in Nigeria. A foreign entity can register their market to carry on your tax. Yeah, to carry on the spread of your business or with your technology and or whatever it is. So licensing and contractual issue. This I countered this during the course of last year, where someone had wrongly licensed a trademark to someone. In fact, they just applied to register a trademark, and this is for a technology for a bank that applied to register a trademark, and then the trademark cannot be registered. They were still in the process of registration, and then he assigned the trademark to the bank. For some reason, I don't know whether it was as a result of improper due diligence and everything, the bank paid for that assignment. But clearly, within the scope of the Trademark Act, that assignment is not valid because you can't assign what clearly has not even been recognized by law to be your own, at that point. And then we had a whole lot of back and forth and all whatnot. So licensing is very important, and then you need to look at your contracts. You need to look at your contracts. For instance, another critical thing now, open source software. You go to a software. I mean, you try to use the software that is open for everyone to use, and then when you use it, the compliance requirements that you are supposed to adopt or comply with, as it were, your engineer for some reason does not comply with those requirements, and then the owners of the open source software decide to say, Mr. Man, you used this thing, we allowed you to use it, but XYZ are the requirements that you're supposed to comply with. You didn't comply with it. It then becomes a problem. Confidentiality failures and trade secret leaks. This has to do with when you're engaging people from the get-go. You do your NDAs. Since currently there's no law that sort of protects trade secret in Nigeria. You do your NDAs right from the get-go to ensure that anything you develop during the course of that relationship doesn't
Hi, Emmanuel, we lost you again. Can't hear anything you're saying.
I said next slide. I don't know what I.
Okay, you have about 2 minutes more, so
You
you're buffering.
Okay, the next slide is up. You can continue. Next slide is up.
you still can't hear?
Okay, we can
All
hear
right,
you now.
thank you so
I was saying the
thank you
next
so
slide is
much.
up.
The next slide is all right. The next slide is the technology and then technology and telecom specific disputes. A couple just the pointers on a couple of things we all need to do as lawyers. Yes, so technology, clearly as it is, technology disputes often arise because those digital assets do not always fit neatly with traditional legal categories. And I tried to explain this earlier in my presentation, where I had mentioned that unlike those physical technological assets those physical assets that when you build, it's here, and then you know how you can transfer your products. I mean, you know how you can transfer your rights and all whatnot. Technological products are what I call, I mean, especially the ones I call soft technological developments. They involve a layer of ownership, access rights, licensing arrangements, and then legal dependencies. Most of them tend to depend on other things. So for lawyers, it's always key that we ask questions, not just about who paid for the technology, but who owns the underlying intellectual property, as it were, and what happens, and what happens, or what kind of rights were granted for the use of that intellectual property, that intellectual property. So I identified a couple of them. Software ownership disputes. I already explained what this entails. The question usually who owns the code. This may involve software development. Developed by employees, like I explained, independent contractors, consultants, technology vendors, business partners. The answer most of the time, it depends on the factors like the contract, the employment relationship, and then the assignment of the intellectual property, as it were. I'd also identified software as a service disputes. This involves situation where and that's what is there as SAS, just for context for everyone. This involves situations where the users access software through the internet rather than owning or receiving a copy of the software. The legal issue that they would typically see here, for lawyers most of the times, is usually the distinction between the right to access and use the software, and then secondly, the ownership of the underlying software itself. So one thing I'd already explained something about, if you remember in the last slide, I'd explained something about open source software. And then this is essentially that kind of situation. And then AI generated works. This is an emerging issue, emerging area, and a whole lot has been said about AI and all whatnot. Who owns AI generated technology? So the technology is developed by AI. Who is supposed to own it? You go to your chat GPT and then you try to develop something, or your Claude or whatever AI you're using, and then you develop something. Who can own it? The position of the law currently, especially because, again, as far as Nigeria is concerned, we do not have a specific law as it is now that regulates AI development, ownership and assignment and everything. So the current position of the law as it is now is that AI cannot own an invention. So, and this is clearly said. This is clearly backed by a complete reading of the Copyright Act of 2022. Who provides for the kind of category of work, and then also defines who an inventor can be. And then also there's this popular UK case. It's called, I think, the Durban case or so, where the court had clearly said, oh, you know what, for you to be an inventor, you have to be a juristic person. It's either you're a natural human being or a corporation, as it were. So clearly, these are now issues that are still going, that are still ongoing. And then there's this popular case. It's a US case where someone had attempted to take a photograph, and then for some reason he didn't click on the capture. It was, I think, an animal or so that, I think the camera fell or something, and then the animal then I forgot the name of the particular animal, then clicked, then captured the image, and then the question was that who can own it, and then the court came to the conclusion that, you know what, an animal, as it were, is not a juristic person that can own. You cannot enforce the right of ownership of an animal, as it were. And then there are domain name disputes. I already explained this under trademark. The owners of the domain name have had to handle a couple of matters relating to the www. I think, yeah, .ng name. You know, who owns the domain name and all whatnot. When if there are conflicts, as it were, over online identity, and then issues around brand protection, how then do you manage it? You know, in Nigeria, in Nigeria, those kind of disputes may typically involve the NG domain namespace that is being administered by, we all know NIRA. NIRA, yeah. NIRA is the agency that is an association that manages that, the domain name.ng. Then while international disputes, for those cross-border ones, they are usually people tend to rely on the WIPO uniform domain name dispute resolution policy to try and then resolve some of those issues. So we need to have most of these things at the back of our mind when we are dealing with technology. And then there are cloud migration disputes, which typically arise when businesses move their systems and data to cloud platforms. What kind of cloud service are you using? The challenge usually is separating the ownership of the data that you're moving to that platform from the ownership of the software or infrastructure, and then intellectual property used to process the data. So as lawyers, we must always consider the contractual rights, data protection obligation, confidentiality, and then the IP ownership is very, very critical. The company reaches out, they want to move to a particular cloud service, you need to be sure what is set out within that contract. And then the other part of this slide that talks about telecommunication disputes, and then some of them, I think this is very interesting. Telecommunication disputes, as they are more complex than the traditional commercial disputes. So for a lawyer, if you approach telecom disputes with the bare contract law understanding of disputes, you might actually just miss it. So you need to approach it with the mindset of a lawyer that has a bit of understanding of the combination of technology, IP, and then regulatory obligation, and now also the general commercial arrangements. You know, understand the purpose of the contract and all whatnot. The underlying issue is usually not only who owns a particular technology, as far as telecoms are concerned, but you know, who has the right to use, modify, commercialize, or access that technology. And then some of those disputes, usually I've identified some of them. The first one is network software ownership and licensing. Is a major area of disputes between because modern telecoms sort of depend heavily on software to manage traffic security, billing, authentication, and service delivery. You know, you just dialing to us, we just dial our phone and say *901 or whatever it is, and then something comes up. You know, you don't know that a whole lot of work happens behind the scene, and then there's a tech team that is not sleeping for you to be able to do that anytime you want to do it. So disputes usually arise over the ownership of certain customized software, you know, rights to update, modification, source code, access, and then the scope of your software license. You remember that just some few about 2-3 years ago, a couple of banks changed, and this is just me trying to use the banks now, for instance. They changed the various codes they were using to Some of them changed the codes they were using to make transactions. Assuming you want to use the USSD, you also see them updating their apps every now and then, modifying and adjusting just to meet up with the client demands and all whatnot. So what happens to those changes? Who owns those changes? Is it the engineers and all whatnot? The critical one I want you to have at the back of your mind, especially because of this new 4G and 5G whole everything that is happening around the 4G and 5G, is the obligations dispute that can arise from obligations around the SCPs and then the front licensing and front licensing. So as far as SCPs are concerned, right, this is very, very critical, because technologies like, say, 4G and 5G, they depend on industry standards, that incorporates some of these patented inventions. So SCP owners, for instance, like I'll give you a popular example, the Ericsson and Transion case now. We've all seen it, we've all read it, we know what it's about, where Ericsson said, see, I developed this 5G. If you want to use it, you need my license. And then they sued them in India, they sued them in Brazil, they sued them here in Nigeria to say, no, you can't use this network if you don't want to come and get the license. I'm not saying you don't have access to it. Obviously, the law says I'm supposed to give you that access, that license, right? But however, you need to come and get the license, pay for it. You need to pay royalty for it. That's sort of what that's about. The case, that particular case, is about. And then technology transfer arrangement, I've spoken about this, where I said you need to always ensure that you advise your clients, especially those people importing technology, you need to register that particular technology with NoTap, so that you ensure that you are properly, your transactions are properly in compliance. So just like I had mentioned, telecommunication disputes are rarely purely IP disputes, but they sit at the intersection of technology, IP, contracts, regulation, and then most importantly, commercial strategy. What does the client want? Always have that at the back of your mind. So as a lawyer, don't just go with the mind of, oh, what is contract or contract law, and go with your contract textbook. You need to understand how technology works, how technology contracts work, and then what is the regulatory framework, and then what is the ultimate more importantly, what is the ultimate strategy, or what does your client wants to achieve? So it's not about whether you want to win the case or no. What does my client want to achieve? My client wants to stay in the market. So it will certainly, in the case I'm paying the royalty, allow my client stay in the market. If the answer is yes, then that's the angle you should be advising your client. So the greatest commercial lawyers are not the ones who are always first to recommend people to recommend cases to court, but they are the ones that look for the best commercial, the most commercially suitable outcome of a case for their client. Next slide, please.
Okay, I was going to tell you that your time is actually up, but so how many more minutes do you need to finish?
Just 5 more minutes, and I'm done.
Okay. So am I on the slide? Am I on the slide you want? Is this the slide you want? Can you see the screen?
Yes. Yes, practical litigation issues, right? Yes. So the summary of this slide is what are the things that happen in what can happen when you are faced with a technology situation where you then have to advise a client on an IP issue. Some of the things that depend on the nature of the situation, and everything I've said out here is just to, I mean, it always depends on the situation. Always look, look if there's need for you to urgently get an urgent relief. Obviously, you have to go and get an injunction. Again, because of the lack of proper technical knowledge about some of these things, when you then go to one of my biggest challenges when I approach courts to get an injunction about IP, I've had a situation where a judge had said in a ruling that and I'm not going to mention any name or mention the name of the case. I said in a ruling that IP are not perishable goods, so as such they could wait. And then clearly that demonstrates the lack of understanding of how this works. Because the moment they continue exploiting my product or my brand name or my technology, I am losing. So it's not like it's not a basket of tomato, So yes, you can approach the court for urgent interim relief where it's necessary. You need to identify the real IP owner when you are discussing to ensure that if you're advising your client on an assignment of an IP right, you are getting the assignment from the proper source. When you're in court, or it's always important that you need to get technical experts. I've already spoken to you guys about the case where we even got a technical expert to come and do an expert report to explain the situation of things, and then we approach the court. The court still adjourned for and ordered for NCC to write another expert report because there were two expert reports, and clearly the court was not certain, or the court had very little knowledge on the subject. And then electronic evidence, this is key. I hope we all know that now there is something we call the Internet Archive. So it just shows the state of a particular page of the internet at a particular period of time. So just for the purpose of helping us gather documents, and then we are still trying to test the law, whether that particular piece of evidence will be admitted. I mean, evidence from the piece of from the Internet Archive will be admitted as evidence in Nigeria. We have cases. I have a case currently where that will be ruled on hopefully by when we resume the next legal year. We have cases from Australia and other instances where electronic evidence from the Internet Archive, as it were, because the pages of the page of website typically change over time. So if you need to get, for instance, the way a page was looking at a particular time, you need to go and use the Internet Archive, So we all need to ensure that all your electronic evidence are properly gathered. And then the other ones here about call log, and we're all lawyers. I think we already all know that. And then quantifying damages. This is another critical part. As far as IP is concerned, within the technology is usually difficult. You can't MTN can give you a projection of what they can make in the next quarter, but you can't say for certain that this is what exactly they are going to make. So those projections are usually based on what they've done in the last 2 quarters, and then the difference between what they've done and then the efforts they are going to put in. So you can't certainly say that this is the amount of money we are going. They can give you a range. So it's always a problem. So you need to guide your clients properly, and then arbitration and litigation. You need to look at section 5 sub 1. On the that's I think it's about stay, and then also because the public opinion issue. IP rights most of the times, especially like copyrights, they are usually rights that are provided for by the law, and then public opinion backs it. Whether it will be there's this debate, although still at its infant level, whether it's even possible for you to go and arbitrate the ownership of a copyright, especially when it's clearly provided by the law. That's still at its infant stage, so it's something that's going to develop in the coming years. Next slide, please. The next slide, essentially, in summary, and maybe she's still trying to. Okay, the next. All right, great. The next slide essentially is talking about things we need to know as commercial lawyers when we are dealing with this kind of contracts. Always try to trace the ownership is very, very key. Then the licensing, how is the licensing moving? You know that, for instance, rights like trademark rights are territorial in nature. So you might, somebody giving you a license, somebody who owns the trademark of a technology in the UK, giving you a license to use that, or maybe a trademark, for instance, in the UK, giving you the license to use the trademark in Nigeria, that will not suffice. You need to go and register it because it's territorial in nature. So that's like, then also improvement and derivatives. Who is going to own modifications if modifications are made to technology? If there's already progress within the engineering space to move network solutions from 5G to 6G. Is it 6 or whatever those are already in works. So those modifications that they are going to make, And I'm sure that the MTNs and the Glos and the big guns of current Nigeria are currently already looking out for some of these things. But when it happens in 2030, 2029, where do we want to be, as it were? So you need to be sure about what is being modified, what is being changed, who is going to own it, so you know when NCC gives a license for somebody to use it, you know how to go out, and then if you want to go and get it and then make modification, essentially, who owns those rights, who is going to own those modifications and everything, the source code. I've spoken about source code already, confidentiality. I've spoken about this. I think we can move to the next slide for the want of time.
Okay, done.
All right, so the next slide is about practical tips. You need to just identify just 4 things you need to know as lawyers. It's important. Due diligence, verify IP ownership. You can't even overstate that. Always verify IP ownership, and then the chain. In landlord, they call it the chain of the title or something. It's important that you track and verify the chain from the source. That way you are able to advise your client properly. Review the registrations very well. Review the registration, go to the registry, check, are there challenges? Is this a registration that is currently being challenged before you go and acquire? And I told you again from experience where I had to advise a bank during the course of last year over somebody selling or assigning a trademark right to them, a mark as well, because it's not even yet a registered trademark to them, and then they have to pay money for it. So you need to do proper due diligence, and then when drafting the contract, clearly always try to ensure the ownership of the IP right is properly transferred, whether it's between the telecoms or it's a technology that you're trying to develop. People always ensure in fact, not just the technology, also the brand name. I'm sure we've all heard about the whole SAP drama and everything. It's important that you always clearly set out on the face of your contract the IP that is going to be developed from whatever this relationship, as it were, will be going to so and so person within this contract. So it's very, very important. Also address issues around improvement, subsequent improvement from that IP, because developers sometimes can come and develop for you, and then they use whatever they develop for you the next time, and then make 1 or 2 modifications and develop for another person. And then so you need to be sure that everything is properly set up. And then the one about around litigation is it's about preparing your evidence gathering, approaching the federal high court to enforce your IP rights. I think that's all about mediation. If you have to go to negotiations where maybe both parties are sitting on the table, it's just employing your basic negotiation skill as a lawyer, with an understanding that I said that is supposed to cut across understanding of technology arrangements, commercial objective of your clients, and your contractor, your experience as a contract lawyer. So that's
Emmanuel, are you almost done so that we can take questions? This is already 3.
This is my last slide. This is the last slide.
Okay, please.
So the last slide, key takeaway, if you move to that, in modern technology transaction, IP disputes rarely arise because the law is uncertain. They arise because ownership, licensing, commercial expectation, and contractual allocation of those rights are inadequately addressed. So for Nigerian lawyers, success lies not only in enforcing IP rights, but in anticipating and preventing disputes through strategic drafting, effective due diligence, commercially informed dispute resolution strategy. Thank you so much, and I will be open for questions from here. Thank you so much. And apologies again for the network.
Thank you, Emmanuel, for that very insightful presentation. I think most of the requests on the comment section were just with regards to the slides which the SLP have responded that will send out the slides to those who registered for the webinar. I don't know if I should ask 1 or 2 questions, since I haven't seen any questions in the comment section. So I haven't seen any question here, but I guess what I would just want you to clarify is, first, are there other areas in the telecom and tech sector that lawyers should actually pay attention to. And the article you talked about is on the, where you mentioned the polygraph test, IP clauses, silence and post-procurement analysis. Can we get the title? And then finally, how many steps or France disputes do we have in Nigeria, or is it more of an international thing? And how do we then enforce cross-border related telecom disputes when it arises? Are there strategies or things that we need to know? So that's the question that I have for you. Maybe you can do that in like 2 minutes. Thank you.
Okay, thank you. The question is quite, I don't know whether it's just a question or a couple of questions, but I'll be the case. So it's, and actually, there are other areas within the telecoms, just to answer your question, there are other areas within the telecoms, tech and telecoms sector that, that are actually still emerging, and some of them are even, and so, although some of them I spoke about them in a way that, in the light that some of them are already here, because I've been privileged to handle maybe one or two cases, maybe just one case around some of those industries, as it were, and maybe, and that explains why. But the reality is that there are still other areas. I'll give you an example. Peak blockchain and NFTs, right? Blockchain, the way, blockchain and NFTs, right? And this is just for tech now. This is me dealing with tech, blockchains and NFTs, and you find that as far as they've now developed sort of a procedure or processes, right, that could allow smart contracts, that could automate things like royalty payments, licensing for you to access a particular technology, or sometimes for the musicians as well, for you to access, and everything. And then these areas, there is now a national blockchain policy, but most of all these areas have not, most of some of these contracts, most of some of these areas have not been properly tested, in the eyes of the law. They've not been properly tested. So it's an area that is still coming up. It's an area that lawyers need to study more, try to further know how some of these things are working. Eventually, if we then have matters in court, how are we supposed to address it? And this is me just mentioning some of the gray areas, or areas that are still emerging. And then the issues around the 5G network. 5G network is still quite new to us. As it were, the NCC they are just giving spectrum license to, I think, is it just MTN and Mafab. I hear Airtel have also gotten one now. I'm not even certain, because I've not been privileged to see that, but I'm certain about MTN and Mafab Communications, right? Both of them have gotten 5G spectrum licenses just in the last 2 years now, and then these are sort of enable the deployment of next generation mobile services, as it were, and then clearly we know that as lawyers, that creates an opportunity for us, because the expanding 5G coverage requires significant infrastructure investment, because people are then are going to invest more in fiber networks, base stations, what we call mass, to some of those rural areas and all whatnot, and because these investments are concentrated majorly in those main cities like Abuja, Lagos, and Port Harcourt, and then maybe a Kano, for instance, infrastructure sharing becomes essential. Some of these companies have to collaborate for them to share some of this infrastructure, and then a lot of things are going to happen from those infrastructure sharing. So that's just to mention 2 areas that are still coming up, and then that we need to just sit tight and then look and study properly as lawyers, to see how we can, then the kind of role we can play in some of those relationships.
Mr. Emmanuel, for answering our questions. I see a comment for, let me see if I can get Georgiana. She says, thank you very much, Mr. Emmanuel. I gave you for your brilliant insight and also very grateful to Nba-Slp for, let's see, for this. Thank you, the rest of the webinar. So thank you to everyone who has stayed up until the end. If you're not yet a member of Nba-Slp CMC community, you still have the opportunity to register and become a member. Also, looking forward to other events that the Nba-Slp is organizing and they taking place during the ABCDC and Port. Without any further ado, I'd like to call this session to a close. Thank you, Mr. Emmanuel, once again, and for everyone who stayed up until the very end. Thank you very much, and you have a good afternoon. Cheers, guys.
Thank you. Thank you so much, Rita. Thank you for the moderation. Thank you, Mr. Emmanuel Aditi, for taking us to. I can understand from the presentation that you have so much to say, but you have to compress everything within the very limited time we have, because usually we don't like to let the session start for so long. I saw a couple of requests for your slides, and I'd responded that subject to the permission of the speaker. Everyone who registered for the webinar will get the slides sent them via email. For those who are asking about recording of the session, this session is being streamed live on YouTube, so you can always visit the Nba-Slp YouTube channel to catch a replay of this and all our previous webinars in the CMC series. As usual, we will be back again next Thursday with another very industry-specific conversation bordering on technology, media, or telecommunications with another very cerebral and highly professional speaker who will be taking the next conversation. And we hope that you make it a date with us again. Thank you so much. Once again, please don't forget to be a member of the Nba-Slp so that you can enjoy this session and all other goodies that that is there for you as a member of the SLP. You can always participate for free. And we hope that you make it a date with us next week again. Thank you very much. On this note, please note your CPE certificate to be sent to you via email. All the details needed for that have been collected. Thank you. On this note, we are just going to give you back the rest of your day and say thank you so much. Thank you for all the nice, for the compliments. Thank you for all the comments. Thank you very much for joining. And see you again next Thursday. Have a very good rest of your week and a very peaceful weekend. Thank you. My name is Daniela Victoria Labi, Secretary of the Nba-Slp CMC Committee, on behalf of the Chair of the Committee, Fernandez Marcos Obiene, who is unavoidably absent, and by extension, the Chair of the Section, Mrs. Folashade Ali SN. We're saying thank you so much for joining us and see you next week. Bye-bye.
Thank you. Bye, everyone.